we need, yes.
If we didn't see the one we're supposed to be.
It's nice that you trimmed the number.
All right, welcome back after lunch, 1 p.m. on Wednesday, January 15th. We're continuing conversations about the Bennington 1 election. We have.
Okay.
Nope, sorry, I apologize. I have no idea.
That's okay. It happens. They interject. I just really like continuing to immerse ourselves in just information to build the foundation for the conversations over the next couple of weeks with the Bennington 1 election. So we have both Clerk of the House here with us, Betsy Ann, as well as Legislative Counsel, Tucker Anderson. We're going to start with Betsy Ann. And just let her grab the reins and get us for a ride.
Hello.
Hello.
It's nice to be here. Hello, Government Operations Military Affairs. For the record, my name is Betsy Ann Rask. I am Clerk of the House. For background, I have previously staffed this committee in my prior role as Legislative Counsel starting in the 2011 session. So this is the third contested legislative election that I've had experience with, although this time my role is reflected more in giving you information, general information about the scope of your constitutional legislative authority and procedure. If you have any questions along the way in regard to your authority or procedure in reviewing this request for you to judge member elections. So thank you to Autumn for posting the documents that I've sent to the committee. And I do have two documents to share today. And the first one I will go through, if it's okay with you, Mr. Chair, is a memo that I just sent shortly before I arrived that Autumn is so wonderful to have posted, and I can share it with you now on the screen if that's helpful.
If that's how you would like to proceed, please.
Okay, excellent. Thank you. So can you see this on the screen? Okay, I can try to enlarge it.
And I think we all can find it on our devices as well.
Excellent.
So we're doing memo first.
Thank you.
Well,
Oh,
then it's.
sorry,
Yep.
it didn't load, Betsy.
That's fine, that's fine.
And mine didn't either, it just went back to the General Assembly page.
Okay. Autumn's working on it. You do?
Oh, wait, hit refresh, it pops.
Oh, do we?
Yeah, refresh.
Okay, all right.
All right, look at that.
Yeah.
Text working.
Oh, yeah.
Excellent. So thank you. This memo, this is meant to give you just some baseline information as you proceed to assist the House in its role in judging the Bennington 1 election. So this just provides some background information as we proceed in this role. So just as an introduction, in accordance with statutory law, which is 17 VSA 2605, which provides a process for a House candidate to petition the House to exercise its constitutional authority to judge a member's election. This committee has been referred a petition for the House to judge the Bennington 1 House election and then a corresponding Attorney General report. I provided a link to that report. I think you also have that linked on your webpage as well. So what are we doing here? Why did you get this? And you got it because in the Vermont Constitution, in Chapter 2, Section 14, there is a provision that states that the representatives of the House shall, quote, have the power to judge of the elections and qualifications of their own members. And I'll just note here that the Senate has similar authority to judge its members' elections, its senators' elections in the Vermont Constitution in Chapter 2, Section 18. So what does that mean when you have the authority to judge your members' elections? Well, we know what it means from 1983 Vermont Supreme Court case law. We are always thankful when we have Vermont Supreme Court case law to interpret the Vermont Constitution for us especially in regard to legislative authority. So this 1983 case was called Kennedy v. Chittenden. I think you heard reference to it the other day when you took up this issue. And that Supreme Court case confirmed that constitutional provision, Chapter 2, Section 14, quote, places the final determination of the election and qualifications of the House members exclusively in the House of Representatives of the General Assembly as part of your legislative powers. And we turn to Vermont Supreme Court case law to understand the House's constitutional authority, because in the checks and balances built into the separation of powers among the three branches, it's the province of the court to decide whether Vermont's laws comply with the state constitution. It's the function of the courts to maintain constitutional government. And the Vermont Supreme Court is the final interpreter of the Constitution. So I'm so grateful for their case law and interpreting our Constitution for us. So the court's holding in Kennedy v. Chittenden, which I will describe in a moment, in interpreting the House's authority to judge its member elections, is similar to other case law that it has issued in regard to interpreting the House's authority also set forth in Chapter 2, Section 14, to judge member qualifications. So Kennedy v. Chittenden came first in 1983, but then after that, we had a case called Brady v. Dean, which you'll probably hear again during your ethics training, which was a case in 2001 that the court interpreted the similar House authority to judge member qualifications. And so these two cases together are reiterating the same principle, which is that where the state legislature is made the judge of the qualifications of its members by a provision of the state constitution, the legislature has the sole authority to do so, and courts must refrain from interfering in that determination. So in other words, in Chapter 2, Section 14 provides the House with the authority to judge its members' elections and qualifications. That House authority is exclusive, meaning no other entity controls it. And this is a canon of constitutional construction that is known as expressio unius exclusion alterius, or that's Latin for the expression of one thing is the exclusion of any other alternative. So in other words, when the Constitution declares a thing is to be done in a certain way, it is necessarily implied that it shall not be done in any other way. So the House's authority to judge this Bennington 1 House election is the House's alone. And I'll just note here that the House, this Vermont legislative authority is similar to each U.S. congressional chamber's authority to be the judge of the elections, returns, and qualifications of its own members in our U.S. Constitution. And it's a power that other state constitutions provide to their legislative chambers. Mr. Chair, seeing questions?
Yeah, I was just, member, yes, please.
Yes, it seemed, says the House's authority to judge this Bennington-1 House election is the House's alone. Got it. Does that, the word judge, does that mean simply just go, yea, verily, we accept the results or not, or we just reserve the right to have all the options to do what we want?
I think it's the latter, the options.
The options
to decide what you need.
That's what I
what the
thought,
House
but I want
needs
to make
to
sure.
know to judge that election.
Very good, thanks.
And is qualification defined as standard usage of the word?
So qualifications, we know from the Brady v. Dean case, means at least includes the power to decide whether the House member should vote on a question due to a conflict of interest. If you look at other case law, we have in other states, it's more expansive. It also includes the authority to discipline members and even to, for example, to censure them. And there's a separate expulsion authority built into your constitution. So judging qualifications is really whether we know from Brady v. Dean, whether members should vote on a question or be disqualified. That case was restricted specifically to that voting issue, but it also in other state holdings, it includes the authority to discipline members.
So in this particular case of election, screw up, doesn't apply.
In this case, we're really, the House is operating under its authority specifically to judge a member election. I'll just note one thing that we know from U.S. Supreme Court case law, Powell v. McCormick, judging qualifications and elections on the congressional level does not allow a legislative chamber to refuse to seat a member if on the basis of qualifications not set forth in the Constitution. But what we're talking about here is something different, is just judging who is the member from Bennington 1 or who should be the member from Bennington 1.
Okay.
All right. Thank you. So what happened in Kennedy v. Chittenden? This Kennedy v. Chittenden case law resulted from the 1982 general election for the House Chittenden 6-2 district. In that general election for that legislative district, candidate Chittenden received 788 votes in the general election compared to candidate Kennedy's 783 votes. In candidate Kennedy's requested recount, the recount appeared to confirm Chittenden's narrow victory. But then Kennedy thereupon used statutory law that existed at the time to contest Chittenden's election in Superior Court on the basis of asserted checklist irregularities. And after a hearing, the Superior Court issued a judgment order invalidating the general election results and ordered a new election. And that was because the Superior Court relied on prior statutory law that allowed a Superior Court to consider all contests of elections and to order appropriate relief, including ordering a new election. And the Superior Court in that case applied that authority to this legislative election, this House election, and invalidated the general election results for that House district and ordered a new election. So that meant that Superior Court order resulted in no candidate receiving a certificate of election and therefore no representative being seated for the district on day one of the 1983 legislative session. Because the Superior Court said after the recount, even though the recount results certified Chittenden's narrow win, the Superior Court invalidated those election results so that no candidate held a certificate of election and no candidate then got seated on that day one. So that day one was January 5, 1983. But later in the month, on January 21, 1983, on Chittenden's appeal of the Superior Court order to the Vermont Supreme Court, in the case Kennedy v. Chittenden, the Vermont Supreme Court vacated the Superior Court order as an unconstitutional violation of both legislative and judicial power under separation of powers, holding a couple of things. First, that the Superior Court did not have jurisdiction to adjudicate a challenge to a legislative election under the constitutional provision, nor did the legislative branch have authority to delegate that exclusive legislative power to the judicial branch when the General Assembly passed a law saying, yes, the Superior Court can issue orders on all contests of elections, including legislative elections. Superior Court, the judicial branch doesn't have that authority, nor should the legislative branch pass a law saying that they could have done it. So to summarize that case, the Supreme Court held that the prior statutory law purporting to confer to the Superior Court general jurisdiction to hear and determine matters relating to elections and fashion appropriate relief, and the Superior Court's application of that statutory law to this legislative election by vacating the general election results and ordering a new legislative election violated separation of powers because Chapter 2, Section 14 provides the House with the exclusive, the only authority to judge its members' elections and qualifications. And the applicable statutory law, therefore, was an improper delegation of legislative powers to the judicial branch. And also, it was also an affront to the judicial power because the Vermont Constitution requires that judicial decisions lead to a final enforceable result that is not merely informative or advisory, as described in this other case called In Re Constitutionality of House Bill 88, where basically the court, in response to a request for an advisory opinion on the constitutionality of a bill, said, we don't have authority to say that, to issue advisory opinions because we adjudicate actual contests, matters that need to be adjudicated. So, but that's Supreme Court case law saying Superior Court, you shouldn't have done that. And also legislative branch, you shouldn't have allowed them to do that. The Superior Court took that Vermont Supreme Court case law and issued a subsequent order dated dated January 24th, 1983, certifying the recount results, which was that Chittenden won 788 to 783. Rep. Chittenden was seated the next day, and then the House proceeded with its exclusive constitutional authority to judge this member's election upon Ms. Kennedy's petition. So since we have that case law where the court said this was a mistake in statutory law, the General Assembly responded and amended the statutes to reflect the appropriate constitutional powers of each of the two branches. So we now have updated statutory election law that acknowledges that each chamber has the exclusive authority to judge member elections. So now in 17 VSA 2603, which is called contest of election, that statute allowed individuals to contest an election in Superior Court other than for the General Assembly, an exception. And then statute provides in two separate statutes, the authority of the House, the process for a candidate or specified individuals to petition the House to judge House member elections, and separately for the process for candidates or a specified members of the public or voters to petition the Senate for the Senate to judge senatorial elections. And so each of those two statutes now for the two chambers provide a process where they submit a written request to the Secretary of State for asking the relevant chamber to judge their members' elections, and then it requires the AG to prepare a report for the chamber's consideration. So boom, that's where we are now. And this is the statutory process used for this Bennington 1 contested legislative elections. I'm just going to note here, Mr. Chair, just for in subsequent committee consideration of this issue, I saw at a high level a memo that was submitted to your committee questioning some of your options. And I just want to note for reference here, this footnote 12, I just want to note here that for non-legislative elections currently in statutory election law, here's what the Superior Court can do for non-legislative elections. And I've cited it here, that 2617 VSA 2603. Here's what the Superior Court can do for non-legislative elections. And this might help inform you for what you might do or might recommend the House do. It's up to the House to make its final decision on what is appropriate. But I'll just note here, subsection E provides the following in regard to Superior Court authority for non-legislative elections. After a hearing, the court shall issue findings of fact in a judgment which shall supersede any certificate of election previously issued. If the court finds just cause, the court shall grant appropriate relief, which may include ordering a recount or ordering a new election. If during the hearing, the court receives credible evidence of criminal conduct, the court shall order a transcript of all or part of the testimony to be forwarded to the proper state's attorney. If a new election is ordered, the court shall set a date for it after consulting with the Secretary of State. In ordering a new election, the court shall have authority to issue appropriate orders, either to provide for special cases not covered by law or to supersede provisions of law that may conflict with the needs of a particular situation. That's just a reference for what can happen in other elections as you consider what recommendation you should make for this one. So at the end of this memo, it's just a short memo, just to provide an overview. What I've done here is linked to a document called Sampling of Past Contested Legislative Elections. Thank you again for Autumn. I think this is posted on your committee webpage. This is a doc I just started putting together as when I was in Legislative Council and handled the 2011 and 2017 contested House elections. And it just provides a summary of some of the more recent contested legislative elections. And then at the very end of the doc, it provides a list of all the currently known contested legislative elections in Vermont history. It's based on journal records and then other historical records. And so here are just some notes on reviewing this sampling doc. Note number one is that it has been a custom of the House to seat on day one the member who certified the winner of the general election in cases where there has been no recount, or to seat the recount winner in cases when there was a recount, except that Kennedy v. Chittenden example that we just discussed where the Superior Court incorrectly invalidated the results overall. That was the only time in recent history that a member has not been seated, even though there's a contest. Also, the sampling doc attempts to describe the basis for each of the contested legislative election petitions. So you'll see it in each contested election, a sampling doc. There's a variety of issues why an individual has contested a legislative election. The issues include ballot security, checklist irregularities, like one you have before you, and recount procedures. And in some cases, I'll just note and confirm, the chamber has conducted its own recount where the issue has been kind of focused on were the votes appropriately counted. And in those cases, I've just noted in the sampling doc through highlighting the cases where the legislature has actually conducted its own recount. So just to conclude this memo, this doc is just meant to provide you some baseline information as you are conducting your role in recommending to the House how it should exercise its exclusive constitutional authority to judge this election. I'm here for you along the way. It's a big deal for you to have to go through this. This is just some baseline info. But if you have any questions about constitutional legislative authority or procedure, you have your terrific legislative counselor, Dr. Anderson, and I'm happy to also help you if you have any questions specifically for me in the clerk role.
Thank you so much for that, Madam Clerk.
Mr. Chair, I'm sorry, but I didn't mean to interrupt. But I also, if you would want, I can also provide you with an overview of that sampling doc if you want to go through either today or another time, just based on your timing.
Well, let's go with some questions first and see what that does to the clock. Representative Cooper of Burlington.
Thank you, Mr. Chair. Madam Clerk, is there anything that has happened in this particular election that is contrary to the facts that existed in anything? Like, we've already gone through the entire process. All the committees have met. The canvassing committee has done what it's supposed to do, pretty much. This person is in the seat. And on top of that, we heard yesterday that this is not the first election in this particular district where this happened. We have any kind of involvement with precedent or locked into anything? Is there anything unusual about this in terms of your citing of history?
I think the answer is no, because the House's authority to judge its members. Elections is a continuing authority. The House's custom is to seat the winner, either of the general election or the recount, but then it is your process when there's a contest to proceed to judge that member election. So I think, as the Secretary of State's office described the other day, I don't think there's anything that's directly on point or past precedent that is directly on point to what happened here, but it's close. Actually, the Kennedy v. Chittenden case, I think, is probably the closest one as described in this sampling doc.
Thank you.
Well, thank you.
That's great. We're all here. We might as well run through it.
Yeah. All right, so I'm going to share that sampling doc. Thank you again to Autumn for providing this. I'm going to do share screen. Does that work, Mr. Chair?
Yes, it does.
Okay. Can we see this? Okay. Yes. And I'm going to do something unconventional, which is start from the end, because it goes in reverse chronological order. So here, I'm just going to scroll to the end. This is the list that I currently have of all of our known contested legislative elections. The ones in A are based on journal entries, and I've just described here whether the chamber was the House or the Senate. And then B is from historical records, and this is just from the Wayback Machine when I have just found these in other records that were not journals. I don't have as many details on those in B as I do in A. But if we want to go in reverse chronological order, we'll start with the 1973 Senate contested election of Smith v. Fayette. So here, I'll just note, in the general election, Fayette wins. I didn't have the actual vote results, but I do know the recount results was actually the opposite, the Smith won. So general election, Fayette wins, recount, Smith wins. And so Smith gets seated because they're the certified winner. So the issues raised in this petition, and I'll just note here, I want to note that I have been hyperlinking, but I've noticed that some of my hyperlinks have gone, are no longer working. So one of the things I'm going to do is work on updating these hyperlinks in case you're interested. I have all of these documents that are hyperlinked here, but there's just something broken about my hyperlinks. So I'll work on getting that updated for you to take a look at these documents. I also have them posted in a different place on my clerk webpage. But here in this Senate contest, the issues that were raised in the petition by Fayette, the general election winner, was that there was a failure to secure ballots between the general election and Smith's requested recount, resulting in the judge overseeing the recount to refuse to certify the recount results. The petition requested several things. First, that the Senate refuse to acknowledge Smith's election and deny his seat. B, certify Fayette's general election win, or C, most preferably, declare the election void and direct a runoff election between the two candidates. So what did the Senate do? They adopted a Senate resolution establishing a special election committee to investigate. There's subpoena authority involved. And then this was very interesting. There was not actual committee report, there were individual member reports. So the chair of this special committee of the Senate, chair and another member, recommended that a new election or referendum be held only in the town of Essex, and that those vote results be added to the recount totals of the other district towns. And then two other special committee members recommended instead that the recount results be affirmed. So what the Senate did ultimately, they disagreed with the recommendation to have an advisory referendum. They denied Fayette's petition and they affirmed Smith's results, that he was the winner and he retained his seat. I will move on.
They only had four members of the special committee.
Apparently, I'd have to go back and confirm. I have that Senate journal.
There's a chair and a member, and then two other members.
Yes.
That's an interesting choice.
Yes,
Okay.
needs some unity. They didn't get it. Or a majority, if I can get it. Okay, so in 1977, we had the very interesting House contested election of Nixon versus Emond. So based on the journal entries, in the general election, Emond won by one vote, but the recount provided that Nixon won by one vote. Unfortunately, the journal did not have recorded what the basis for the contest was, the issues about the vote results. But the House established, they adopted, HR 4, which was a committee to issue subpoenas, was introduced, was later ordered to lie, and then it ultimately withdrawn. The final House result was Nixon resigning. The committee conducted a recount and determined that Emond won by one vote, that general election winner, not the recount winner. And Rep. Nixon resigned prior to the House vote on this contested election. On the day of Nixon's resignation, the governor appointed Mr. Emond to the vacancy, and he was seated the following day. So that's how that worked out.
Yeah.
In 1981, in the Senate contest of Manchester v. Hastings, in the general election, Manchester won 5,671 votes to Hastings 150. The issue raised in the petition was failure to timely file a consent form for the primary election. There was just some details about what was happening there. The Senate referred the challenge to the Committee on GovOps, and the special committee report was to reject the challenge and allow Senator Manchester to continue to serve. And that was ultimately the Senate's final vote, that they adopted that special committee report and Senator Manchester retained their seat. Okay, the next fun one was that 1983 Chittenden v. and Kennedy election. So I've already described that. I'll just note general election and recount results were the same, but that was our one-off where no member was seated because of that Superior Court order. I've gone through the details of what happened there, but ultimately the committee report was that Representative Chittenden retained his seat. I'll just note here, that in regard to the issues raised in the petition, I think this is why this is the closest one that's most on point to what you're dealing with today, was that the issue raised in the petition was about voter qualifications. And that 18 voters on the checklist did not reside in the legislative district, and 10 of them voted in the election. And you see that the election results were under 10 votes apart.
So this is the most applicable case where it's about the sanctity of the voter roll itself.
Yes. And voters shouldn't have voted in the election, but they did, and it was, the number of voters was greater than the number of votes separating the two candidates.
That was my question that I asked yesterday, is how many of those 56 long ballots were voted? If we knew if they voted or didn't vote, then you would know if it had any reflection on results. So
Yeah.
And you should know how many of those voters did vote in the election, as you know.
Yeah.
One,
Yes, ma'am.
I don't want to deviate too far, but just one thing I thought of driving this morning, it may have been answered, I may have missed it yesterday, is did that, let's just say the course of action is we pull those voters, whether we vote the whole district, just that chunk, whatever, that's one of our courses of action. Would that then in turn have an impact on the race that those people voted in?
The Bennington Five, in the report, which we're
Trying
gonna
to
go
remember.
like pretty much line by line later,
It's such a huge
they
difference.
said that it did not have an impact on the other districts. Although they are obviously impacted.
Yeah, but
It
it
wasn't enough.
wasn't enough disparity. That's what I thought, but
So that's why we're focusing just
Just there.
on Ben.
I assume that had been.
Yeah.
So in that case, Ms. Kennedy requested that the House declare the election void and order a new one. The petition was referred to the GovOps committee, and the special committee report was that Representative Chittenden was duly elected and qualified, and that's what the House also confirmed by adopting that report. And Representative Chittenden retained their seat. Okay. Next one, 1985, there were a couple, 1985 must have been a happening time, so I think this is the one where there are a couple of them. We'll start with Stokes and Painter in Chittenden 4. So here, general election, Painter was the winner, 1651 to Stokes 1632. But the recount was that Stokes won, 1641 to Painter 1638. So some changes there in the counting. And the issues raised in the petition was that there were accounting errors in the election of the recounter, both recount accuracy and recount committee failure to examine ballots. Those were the issues raised in Painter's petition. Painter being the general election winner, but the recount loser. So what did the House do? The House adopted a resolution, HR 5. It allowed the GovOps committee to subpoena ballots in both this one and the next one we'll get to, Woodward Green, same year. And related documents, and to be assisted by other members for equal political representation and to count the ballots. And so they did. They conducted a complete recount, and their recount results was that Stokes won 1649 to Painter 1632. So again, the legislative election still came up, legislative recount, came up with some different vote results, but this was what the House did to address this contested election. So the committee's report was that Stokes was duly elected and qualified, and then the House ultimately adopted that special committee report. So Stokes retained their seat. What a fun time in 1985, because we also have in Chittenden Franklin 1, Woodward Green. So in that case, maybe not as fun that we can say now we're behind this, probably wasn't fun for these people in 1985. But the general election, it was Woodward's 807 to Green's 800, recount Woodward's 803 to Green's 801. So a little bit of difference, but still maintaining Woodward as the winner. So issues raised in that petition by Green was that there were counting errors in the election or recount or both, recount accuracy, and failure of Superior Court to issue a judgment. So again, the House adopted that HR 5, same as in that Stokes Painter one that we just reviewed. And again, committee conducted a complete recount and affirmed their results, different results, but still affirming the same winner, Woodward's 806 to Green's 801. And so their report was that Woodward was duly elected and qualified, and the House agreed. They adopted that report. So Woodward retained their seat. Nineteen ninety-seven, we had a Senate contest, Maynard and McCully. So in the general election, Maynard was the winner. It was close. Recount, Maynard was still the winner. McCully's petition stated that there were incorrectly counted or missing votes, and there were issues with the recount procedures. So the Senate adopted SR 5. It created a special committee, it had subpoena authority, and their report was that Senator Maynard was duly elected and qualified, and the Senate agreed. They adopted that report, so Maynard retained their seat. Okay, then we get to 2011, House Windsor Orange 1 district. This was Representative Buxton versus Ainsworth. These two candidates, went back and forth actually, in getting elected. In this one, Buxton was the winner in both the general election and in the recount. But look how close it was. Buxton's 882 to Ainsworth's 881. Recount still maintaining that one vote difference, but just the count was slightly different. Buxton's 881, Ainsworth 880. So issues raised in that petition were voter qualifications, how they use provisional ballots, security of the ballots. GovOps issued a special report that Buxton was duly elected and qualified, and the House adopted it. So Representative Buxton retained her seat. Finally, our last one was in 2017, House Orange 1 district. This was Representative Frenier versus Susan Hatch Davis. So in the general election, Frenier's one was 1853 to Davis's 1845. Recount certified Frenier as the certified winner, 1852 to Davis's 1845. I'll just note here, this is confirming here. This is great to have this precedent for me, my new role, because at the House's organization, a member raised a point of order that Rep. Frenier was not qualified to be seated. So a member challenged the ability of Representative Frenier to be seated because of this contest, and the Secretary of State ruled it not well taken because it didn't comply with the House's custom of seating the recount winner. And so Representative Frenier was seated because he was the certified recount winner. So the House adopted a special recount panel with authority to subpoena the ballots and witnesses and conduct a full recount. And the House also adopted HR 10 that established policies and procedures to conduct the recount. So I was staffing the GovOps committee at that time. And on that morning, we discovered an error or an issue that violated a provision of the HR 10, Part 2, Section 5C, which provided that if a seal or container from a county recount is found to not be intact, the panel recount shall not move forward and Rep. Frenier shall retain his seat. On the morning of the panel's scheduled recount, we were meeting in room 11. The panel discovered that a ballot bag had been opened following the county recount, so they didn't move forward with conducting the recount. And so in accordance with that HR 10, HGO special report recommended that Frenier be found to be duly elected and qualified, and that's what the House did. They adopted that special committee report, and Rep. Frenier retained his seat.
And so essentially a bag of ballots had its seal unsealed
Yes.
in layman's terms.
Yes. No nefarious, nothing nefarious. It's just,
Yes.
that just is what happened.
Gotcha.
Okay, that takes us to today, 2025. You know, you have this one before you. So this one gives background. That was just background information on some of what the legislative chambers have recently, if it's helpful to help inform you what your options might be, or how you would consider this, but it doesn't bind you because a prior legislature does not bind the current one. The House's power to conduct elections, the continuing power. This committee is to make an alternate recommendation on House on what we should do on this specific election.
No, thank you very much. I mean, that was a lot to digest. As always, I thank you for your ability to break down the immensely complicated into a digestible format and present it clearly and concisely. So thank you so much.
Thank you. Happy to be here.
Remember,
Yeah,
The point of order wasn't well taken. I mean, I remember him citing Rule 75 constantly. He was like, pursuant to Rule 75, I abstain.
Oh, that was on whether Rep. Frenier could vote on the special committee report. Yeah, so, and that wasn't
Oh, yeah, it was
appropriate.
like, it was conflict. I think.
That was
Yeah, it
appropriate.
was, but I feel like he did it for weeks. Like, is that true? I can't remember quite.
I don't remember the.
Like, I feel like he had to do it several times.
It was for, I recall it specifically for the House's vote on the GovOps report on whether Rep. Frenier should be considered duly elected and adopted. And House Rule 75 provides that a member shall not vote on a question in which they are immediately or directly interested. And so that's interpreted in regard to conflicts in voting. It could involve a conflict of interest, like a direct pecuniary interest, which happens very rarely. But it does apply when the question is about a member specifically, such as, for example, we think of whether to censure a member, that's about a member specifically. Completely separate was the question on whether Rep. Frenier should be considered duly elected and qualified. That involved Representative Frenier specifically. And so the House is, I think
Oh, maybe it's because, yeah, I feel like we just had several votes on the question, sort of, or like, maybe there were amendments, I'm not sure. He kept doing it that day.
Anyone else have any questions for our esteemed clerk? No, thank you very much.
Thank you.
Thank you, thank you.
Can we get those links? for you?
Yes, we're gonna
Ask you about that, because most of them didn't work.
No, I was so upset about it. I'll work on that.
It worked out to the second.
So we do have the Attorney General's office coming in at 2. I don't know if Tucker has anything to add. No? Okay.
Wonderful job done.
Please,
Mr. House
yes.
Clerk.
Most of the committee special reports listed here that Betsy Ann provided, they were completed around the beginning of February. Do you expect us to have a similar timeline, or like any guess?
I mean, I'm hoping to be able to move a decision. First week of February is just kind of what I got softly plugged into my
Keep
head.
in mind that if we decide it has to have an election, we had it 45 days.
That is all something that needs to
So-
be into consideration. It is a 45, well, it's actually more than that. It's closer to 60 because we had 2 weeks worth of getting it ready, printed, and then the 45-day period.
45-day period.
That is also a thing that but we also have to do our due diligence, we take customary that we need to. So there's there's a lot of variables, remember. So, well, if there aren't any other questions for the moment, let's call it. Let's just take a break. That was a lot of brain activity. So let's take a time out. And we will come back at 1:55 and wait for the Attorney General's office